Thank you very much for joining us tonight for what I think is going to be a very exciting, very important event, very timely event as well on Bill C-78 and equal shared parenting. Just a few housekeeping items. You might have seen the signs at the doors, but if you didn't, let me remind you that we are video recording tonight's event. In fact, we're live streaming it, and we've got probably a couple dozen people watching online right now, but the footage will also be put up on our YouTube channel, which is youtube.com/EqualityCanadaTV. You want to share that with those who could not make it tonight, please feel free to do that. The video will be up in a couple of weeks, but there is video recording, so we wanted to disclose that. As we say at all of the events that we host here at U of T, the University of Toronto has certain policies around the disruption of meetings and events, and we're always very rigorous about following U of T policies as far as that goes. I don't anticipate there being any disruptions, but just so you know, we do take those policies seriously, and we will follow them very closely. Out front, you probably passed a few tables. Let me tell you very quickly, there's some sign-up sheets there. You can get more information by grabbing a brochure or a flyer. We also encourage donations. We're a charitable organization, and we survive based on charitable gifts to keep our services and our programs running, which I'll tell you about in just a moment. So you can also support us by becoming a member or purchasing merchandise, t-shirts, mugs, etc. They're all there at the front table, and our kind volunteers, I'm sure, will be happy to answer any questions you have out there. I want to thank you again for joining us tonight. Let me just acknowledge that this event is being hosted by the U of T Men's Issues Awareness Society. We're very privileged cafe that is to partner very closely for a number of years now with the U of T Men's Issues Awareness Society. We think that the issues that we bring to the university are critical issues, in many cases life and death issues. We've talked about men's suicide, we've talked about domestic violence and sexual abuse as it pertains to male victims, issues you don't really hear very much about, but they are critically important nonetheless. And we're very pleased that through that relationship between the Canadian Association for Equality and the local U of T Men's Issues group, we've been able to bring events to this campus on a roughly monthly basis now for about 6 years, I suppose it's been. So we want to thank the U of T Men's Issues Awareness Society. And just very briefly, CAFE, I've mentioned that acronym now a couple of times, is the Canadian Association for Equality, a registered charity that is very focused on gender equality, but in particular a unique focus on integrating boys and men, their perspective, their issues into efforts to achieve gender equality. And our focus is on domestic violence, our focus is on family law reform and equal parenting, which is why we're here tonight. Our focus is also on men's health. We run a men's health facility called the Canadian Centre for Men and Families. So enough about us and enough about CAFE, but let me tell you a little bit about the speakers we're going to hear from tonight, and then also a bit about the format. Now, you might have heard that we had to make a few last-minute changes. Well, I guess 2 last-minute changes as a result of unforeseen circumstances. Unfortunately, Michael Cooper, I'm hoping this isn't news to very many of you that you got the announcement ahead of time, but Michael Cooper is unable to be with us. He was sort of called back to Ottawa, I suppose, to deal with the SNC-Lavalin affair, so that's what he's up to, and he sends his regrets and wishes he could be here, but business is what it is. But in any case, we're very excited to have announced a new panelist, Martha McCarthy, who has joined our panel. Really are appreciative of her doing that at the last minute. It means a lot to us. Martha McCarthy has practiced family law for over 25 years. I'll get into her detailed bio in a moment, but we're lucky to have her join our panel. We have a really solid group of 3 people here tonight, and I think you're in for quite a treat. The way this is going to work is we've had to retool it a little bit. What we're going to do is we're going to have Mike Glover. He's going to speak first. He's going to talk for about 7 minutes, giving a bit of a sense of his personal story and how equal parenting affects him at the personal level, which will kind of set the scene for the debate that will follow. He will then ask the first question of our 2 panelists. By flip of a coin, we've determined that Brian Ludmer will go first. When we do get to the questions, the way that will work is that the question will be posed to the first individual. That person, he or she, will have 2 minutes to give their answer. Then the other panelist will have 3 minutes to respond, rebut, however they want to take that time. And then the first speaker will have 1 minute to come back in and sort of close off that particular issue before we move on. Hope that wasn't too complicated. You'll probably get a sense of it pretty quickly. What I'm going do now is, I think, because I've been speaking for so long, I'm going to introduce Mike, and he'll come and he'll speak for 7 minutes. Then I think I'll come back just before Mike gives his first question to introduce the other two panelists. So let me tell you who Mike Glover is. So Mike Glover is an IT executive working in the GTA and surrounding areas for the last 30 years. Mike is originally from Burlington, but when he was 9 years old, his brother and Mike were abducted by their father, and they were brought into the United States. As one of the first public abduction cases, there was a great deal of publicity regarding their situation. 5 years later, fast forward to 1982, his mother found him in Missouri and returned him to Canada. 9 years ago, Mike's divorce started, and in the process, his children became severely alienated from him. So he's now an activist for equal shared parenting as a result of having seen both sides of the coin with respect to the Canadian family law system. So we're really interested to hear more about that story and other things Mike has to share with us. Mike, where are you? There he is.
Hey folks, how are you? Can you hear me? Yep. All right. I used to teach in these halls. I used to teach computer science. I was just about to ask you if you handed in your algorithmics homework, but we'll pass on that. Yeah, actually, as Justin said, that my brother and I were one of the first major abduction cases in Canada. We were actually pretty high profile when we were returned. We were gone for about 5 years. We started off in Florida. We bounced around the United States a bit, Missouri and what have you, back in Florida, back to Missouri, all in a span of 5 years. And it was in Missouri where my mother caught up to us. We went through a relatively quick court case down in Fulton, where a decision was made that my brother and I would return to, as they called it, the Dominion of Canada. From the time my parents announced the divorce to the time that I was returned, there were a lot of desperately deep, impactful events that happened in succession that didn't really end when we returned. In fact, the damage continued on both sides of the house with my father and of course my mother as well. When I was about 8 years old and we were put into an every other weekend circumstance with my father, my brother and I recognized that our relationship with the father was becoming strained and difficult because we didn't see him. We were interacting with him the same way. He was a very attentive father prior to divorce. He's one who took us to the swim events, took us to practices, deeply involved, and then one day he's not there anymore. Our world was turned upside down. Divorce does that, and that's just unfortunately part of the equation. But when you go through a process of abduction, the world you live in is vastly different, and you learn this after the fact, than what everybody else lives in. You're paranoid, you have no trust, you're concerned about your life. We were very, very, very poor. The lifestyle we lived, it was extremely difficult, to say the least. When we came back to Canada, although we had better financial means, the impact of the relationship between my mother and I, my brother and my mother, still exists to this day. Although I have a good relationship with my mom and I see her talk to her all the time, my brother does not. And my brother is 52 years old, and I don't think that relationship is ever going to really kind of fix itself. How could people in shared parenting back then have changed the history? Well, my answer is actually quite significantly. My father did what he did. I understand what he did. It doesn't mean I agree with it. He did what he did because he was losing his relationship with his sons, and he didn't want that. Nobody was listening to him. Nobody was helping him. No one was giving him the right to speak or the right to the opportunity to his children as he had when he was a married father. So he did what he did to preserve them. Unfortunately, it backfired dramatically, unfortunately, but once again, I understand it. The pretense of a rebuttable equal share parenting back in the 70s would have avoided the abduction process my brother and I went through, the pain we lived through, and I'm talking real and significant and severe. that to this day, my brother and I still kind of harbor, if you will. It doesn't affect us day to day, but there are times, noises, sounds, what have you, that bring a lot of that back at times. And it's something that you learn to live with. Flash forward to my divorce. And I'm not going to go into details with that, but equal and shared parenting would have had a dramatically impactful on the circumstances that I'm currently dealing with now. I'm not going to go into details with it, unfortunately, because they're pretty ugly. But it's not about me. It's about my kids and what they've been through. I'm sorry?
Mic closer.
Oh, sorry. It's about what my kids have been through and what they've been forced to endure as well. And I know what they're living through. I live through it myself. So I can empathize completely with regards to the pain they feel and the pain they express and the anger they have that is core to their being now, unfortunately, which was never there prior, but it's certainly there now. A rebuttable and equal share parenting circumstance with regards to my divorce and, more importantly, my children, a lot of the damage and a lot of the hurt that they have endured, and they have, would have never materialized. And we talk about the best interests of the children in family court all the time, and my position is they got it wrong.
It's a joke.
It's bullshit.
They never mentioned kids in court.
They don't think about it.
Excuse me, guys.
I understand it's a sensitive topic.
I know, but that's exactly why we need to be respectful of the structure of the event. So please let Mike conclude his remarks, and then perhaps we'll take one or two questions for Mike, and then we're going to go on to the rest of the event, and then there will be a question period at the end. Okay, so please hold on to those.
And I feel your hurt, I feel your anger, and I know exactly where you are on myself. Right? And I agree with your sentiment. I argue it's actually the best interests of the family that needs to be addressed, examined. Children have a right to a relationship with their parents post-divorce, as healthy and intact as it was prior, and I would argue with some support advancing that as well. But I also argue that they have the same rights with their grandparents, their uncles, their cousins, and what have you. Those people around them, the family at large, are the people that mold them, influence them, grow them, mature them. They're all fundamentally important. And as such, just focusing on what we think are the rights of the children, I think is too narrow a scope. I think we really need to look at a larger picture and understand the circumstances. My mother hasn't seen my children in almost 5 years. It's not her fault, she wasn't divorced. Right? So, with that said, we obviously have two diametrically opposed lawyers here with regards to the positions. And I understand both sides of the equation, by the way, I do. I don't necessarily agree with one all that much, but I understand the arguments at the very least. And I was asked to provide a question to my friends here, which I will do. I really struggled over the question, to be honest, because I didn't want to come off too lopsided. We are here to debate equal and shared parenting, more importantly, the rebuttable position of equal and shared parenting, and what that means to family law and the families at large. When I talk about family, I'm talking about everybody.
Questions for Mike, specifically?
Have you not seen your kids in 5 years, Stu?
I'm sorry?
Your mother not to see?
Have I not seen my children either? Well, I'd love to answer that. I don't want to get into personal details in that regard, but I'm going to answer it the best way I can, and to be fair, is the relationships with my children and my family have been truncated in varying degrees, if that helps.
All right.
We'll do two more, and that's it.
All right. So I travel from y'all, I like to see this. I think really that most of us are in the same boat here, that we don't see our kids, that the courts are generally a failure. I've never had any luck in court since 1993. I've had no relationship with my children since 1993. So I was hoping to meet a politician. However, if I was to pose a question, rebuttal of equal share parenting, is this in the best interest of children? Then my question would be, why would anybody think otherwise? I mean, 20 years of science can't be argued. There's no argument here, and this is why I wanted to, why would the politicians treat us this way? You'd say 5 years, it's been almost 20 years since I've seen my kids. What do? So, again, as a Canadian, why are we treated this way?
Thank you for your question. Let's hear what Mike has to say.
Well, that's probably a better question to pose to the lawyers here, because they obviously deal with the
Mike,
courts.
just repeat the question.
Oh, sorry. Why is the court system,
No, but why would the politicians want to treat people this way?
why would the politicians want to treat this?
To enhance family. So it doesn't add up.
Well, I can tell you what I personally think, that the issue is we're dealing with a very complex problem that requires a tremendous amount of history and insight and education. And we get that in droves if we're involved in it. We get a crash course. Politicians are in place for 4 to 5 years. It took take probably 3 to 4 years to get somebody on board, and boom, they're gone again. The issue is we need to be able to get to the politicians with a stronger message faster to get them to understand it better sooner, so they can make better decisions that I think overwhelmingly the Canadian public think are actually the right way to go.
Yeah, my daughter...
No, hold on, guys. There is a format. Because this is such a sensitive topic, it's even more important that the format actually be maintained. So we're going to have one more question. Somebody who hasn't asked a question, please make it a question to Mike. Yes, at the side, please.
Well, I'm not sure if this is so much a question, but it's a comment. This isn't going to change until, because in my opinion, and I've been going through this for 18 years, that this isn't going to change until the ladies stand up and say enough is enough, because it was the feminists that brought us these unjust laws in the first place. And it's going to take the ladies to stand up and say enough is enough. We believe that fathers are just as important, and that's the only way it's going to change. I circulated...
Sorry, sir, can you turn that into a question?
So the question is, would you agree with that?
Okay.
In totality, not entirely. I believe that if we are going to make change, then a unified effort is absolute. That means men and women regardless, and we all have to be singing from the same page. I'm a member of a number of Fathers for Equal Rights groups, and I think the women's numbers are pretty high. I think we're sitting 30 to 40%, and they're on the same page with just as many. Well, I'm not going to say just as many women in the same position, but there are a lot of women in the same position. Do I believe the feminists are at fault for this? I wouldn't do that. That would be, I think, I personally think it's a little overbroad. I think just bad policy has put us where we are, and changing policy is a difficult thing to do, unfortunately, and it's just the nature of the political beast. I'm going to go back to my original answer is, if we can, in a unified way, reach the right people sooner with a stronger message, I think we would have a better chance of making the change that we all think is necessary. And I don't think we're quite there yet, unfortunately.
Thanks, Mike.
You think it's got to do with money?
We'll have time for more questions towards the end of the event. Let me just say, sort of put our cards on the table. Our organization does have a position on this. It would be disingenuous of me not to disclose that. In fact, we've been involved in building a coalition of groups which has been presenting before the House of Commons Justice Committee, which has been looking at Bill C-78 and family law reform, and actually arguing the case for equal share parenting through the coalition of groups that we helped to build. Nevertheless, this is a conversation, a debate, an exchanging of ideas, and that's why I'm going to keep reiterating how important it is that we are respectful. We make this about the issues and not target the people, that are on the panel or anybody in the audience, okay? So I ask for your cooperation on that. Let me introduce our two other panelists, and then I'm going to recall Mike to ask the first question of them. So first we have Brian Ludmer, who's a Canadian attorney with a practice focusing on cases involving high conflict custody battles. Brian is also a business and securities law attorney with over 32 years of experience. He's the legal column editor of the newsletter of the Parental Alienation Study Group. He's a frequent speaker for Family Access and is widely quoted across the media. He spoke at the first international conference of the Parental Alienation Study Group and speaks frequently for the Parental Alienation Awareness Organization, the Children's Rights Council, Canadian Equal Parenting Coalition, and many other organizations across North America. Brian has been speaking to the Ontario Canada Hospital Network on parental alienation diagnosis and therapy. Brian works as a special counsel with U.S. and Canadian attorneys and mental health professionals to assist targeted parents and grandparents. He's also the author, or co-author rather, of the book, The High Conflict Custody Battle. He's an advocate for rebuttable presumption of equal shared parenting. He's the co-founder of Lawyers for Shared Parenting and a member of several family rights organizations. He's an advisor, among other organizations, for the Canadian Association for Equality, and provided the testimony that you heard me just mention a moment ago was put forward by CAFE in front of the Justice Committee. Let me tell you a bit about Martha McCarthy. Martha McCarthy has practiced family law for over 25 years. She's been counsel of record on some of the longest and most complex family law trials in the province involving the most difficult custody and access issues. She's become a leading expert in high conflict custody cases. She was lead counsel in the Freedom to Marry litigation and quarterbacked a national strategy that resulted in the first court decision in the world calling for full and equal marriage for same-sex couples. She was counsel to the individual applicant couples in Halpern and on the same-sex marriage reference before the Supreme Court. Her work in that case and in the seminal spousal support case of MVH resulted in widespread amendments to federal and provincial legislation for same-sex couples. Martha has acted for couples who won the right to put both parents, regardless of gender, on their child's birth certificate. She is a fellow of the American College of Trial Lawyers and the International Academy of Family Lawyers, and has instructed trial advocacy at the University of Toronto Law School for more than a decade. Tell you very quickly some of the awards that she's won. She's received the Sexual Orientation and Gender Identity Conference Hero Award from the Canadian Bar Association, the Ontario Bar Association Award of Excellence in Family Law, the Hope and Freedom Award, and from Toronto's Metropolitan Community Church, and the Law Society Medal. So we have two stellar panelists to join Mike to round out the evening tonight. I think Mike's going to come back up and ask the first question to Brian and then to Martha, please.
So like I said, I actually thought about this question quite a bit, and I wanted to be relatively fair to both our panelists because they're taking time out of their personal lives to be here. And we are here to talk about rebuttable presumption of equal and shared parenting, and there's a lot of dynamics to that. So I thought I'd just kind of set the stage with a baseline question that I think both Brian and Martha can equally answer from their perspectives relatively easily, and I think that might actually get us off to a start, and I think we can take it from there. So the base question is, what do you think the benefits are from equal and shared parenting? What do you think the drawbacks are from equal and shared parenting, and why does one outweigh the other in your mind?
Thank you. So I will tell you why I think equal parenting enhances the experience and the outcome for children of separation. But it's important to bear in mind that the legislative change we're looking for is a rebuttable presumption. So it's not that this is going to be imposed on all families, because it doesn't work for all families. The central idea is that for most families, there is no science behind the determination that one parent should see their children 37.2% of the time. And the only verifiable, peer-reviewed, internationally accepted science that is out there is overwhelmingly in favor of the principle that the closer you get to two primary parents post-separation, the better the outcomes for children. And that science is so robust and so mature now that it can be stated that it informs the necessary public policy change. Secondly, the true experts are not the people who espouse themselves to be experts and who consult, it's the public. Because the public are the ones who experience the system with all its pluses and minuses and difficulties. We have over 20 years of public opinion polling in Canada for sure, but right across North America, that says that the public is overwhelmingly in favor of equal shared parenting for most families. And this cuts across all demographics: age, region, political affiliation, gender. It's pervasive and it's consistent. So the biggest conundrum that we have, and it's a question that, a thoughtful question from the audience, why are our politicians not hearing this? And it's simply because, Mike may have put it eloquently, you need to be properly informed about the background, about the science, about the public opinion, and I'll close by just pointing out two errors of logical reasoning from each of our outgoing Justice Minister and our current Justice Minister. So our former Justice Minister was quoted on this point as saying, equal parenting is about parents' rights, not children's rights. And that's completely wrong. The current system fosters litigation and is about parents' rights. Our current Justice Minister, when posed this question, said, well, this has been tried in other jurisdictions and revoked. That's also incorrect. We know where the error of thought comes from, but it has never been implemented anywhere in the world and revoked. Australia had something totally different, and there is no jurisdiction that had a rebuttable presumption and had a bad experience with it and revoked it. So if we correct the evidence on which public policy is made, we'll get to the right result.
Hi, everybody. So first of all, I think the question...
Push the button.
There we go. Oh, hi. So first of all, I think the question was, what are the benefits of a shared parenting regime and what are the disadvantages? So just to focus on that, which Brian also said, you have to understand that the greater discussion is about, should we have a presumption, right? But just first of all, the actual question posed is, what are the advantages? Or do I agree with everybody in this room that children do best in most circumstances with maximum contact with both of their parents or even in an equal time arrangement? I agree with that, provided one thing: they don't live in conflict and their parents don't fight. And the problem that we have, that you also all can relate to, is sort of the flip side of it takes two to tango, which is it takes only one person to screw everything up. And you can have a family dynamic post-separation in which the behavior of only one parent, for whatever reason, undermines a road towards equal parenting. And that's because there is a legal principle decided by the Court of Appeal for Ontario that is, like in my world, if I'm speaking to you and I imagine for a moment that you have a sort of homogeneous set of goals, the first one I would suggest to you as a group is the Court of Appeal said, and every judge applies in Ontario, because they're bound to follow the Court of Appeal, that in high conflict situations, if one parent says that it's too high conflict for us to parent together, it operates like a veto. And basically, one person says, I can't do it jointly, and that amounts to a veto, even when actually that's not legit, like it's not even real. So if I'm making a list of reform issues for people who wish to promote a presumption of equal time or wish to have every judge think that we should be thinking that way, then overturning that is a really important point. The second part of the question was, what's the disadvantage of being in a shared parenting arrangement? And it's the same as the first answer, which is there isn't a disadvantage unless the parents can't stop fighting. And if the parents can't stop fighting, there can be really serious long-term consequences, even if you're the non-high conflict person. So if you're in a tug of war over a child in the middle, sometimes the low conflict person has to be the one that says, I'm actually not going to rip the arm right out of the socket in order to win this fight. And so it's a very difficult thing that's been created by our case law. And that you challenge with individual cases, you challenge with one good case as a test case that goes to the Court of Appeal, and you say that kind of veto on equal parenting is a huge problem. Okay, I just want to make one other comment if I'm being told I'm out of time on my response, and that is on the discussion of a presumption of shared parenting. I think the reason that I'm invited here to speak is because I met some of your colleagues. Ludmer and I know each other really well. We've had lots of cases together, but I appeared at the parliamentary hearings about Bill C-78, and I got asked a question about a presumption of equal parenting, and I said that I was not in favor of a presumption of equal parenting and that I think it's a problematic idea, okay? But I just want to say in an overview way here that I went to the parliamentary hearings to speak about three things that I think are really ill-conceived in the proposed bill, which are replacing the words custody and access with new language, introducing mandatory mediation as a serious access to justice issue and problem for people who have to access the court system. I think it's very problematic. And adding a whole bunch of presumptions about mobility, which will favor, quote, a primary parent being kind of automatically allowed to move. Okay? All three of those issues are issues that I think, again, assuming you're a homogeneous group, that you should really care about. And I want you to know that the inside scoop that I've received, so then Ludmer comes and says, among other people, with on behalf of this group and other people, he comes and says there should be a presumption of equal parenting and makes that whole pitch completely. I just want you to know that they're going to take up none of our suggested changes. That's what's about to go down here. So we're having it there. I think they're voting on they already passed it without making a single change after we all appeared. Nothing about presumption of equal parenting, nothing about the other concerns. So we're having a discussion that I think when you pick this up next, you're going to have a bill that doesn't have a presumption of equal parenting you're about to get. And I think the question is then going to be, do you want to do some kind of a charter challenge? That would be my suggestion that this group should consider.
Let's pick that up in some of the other
Yep.
Yeah, thank you. So you have, I'll give you a couple minutes.
That's okay.
To balance the.
Okay, just Martha's comments are very insightful. Sorry. Okay, I said Martha's comments are very insightful, but I think there's a way to actually show some common ground here, because the Court of Appeal decision Martha was referring to, the Panelist, is about joint decision making. All of the research published by the world's leading researchers, and in particular I recommend Linda Nielsen of Wake Forest University, shows that equal parenting time as opposed to decision making reduces conflict, and even if there is conflict, it doesn't impact on how much time. Time with the children is time apart. So if we separate the issues and say conflict, you can see how it applies to joint decision-making. But separate parenting time, not only is the conflict irrelevant, but a rebuttable presumption would decrease the conflict, decrease the many years of litigation. So that's where I think we may be able to find common ground here.
Okay. Thank you both. At this point, I'm going to start asking some questions, and we'll try to breeze through these as quickly as we can. So I know we've sort of stated at the outset what the time limits are, but if you can be even briefer than that, that's even better. So the first question I want to get into is the best interest of the child. We hear that term a lot. In fact, Canada signed the UN Convention on the Rights of the Child. Article 3 of that convention states, in all actions concerning children, the best interest of the child shall be a primary consideration. So the question is, how do you define that? What does the evidence tell us, the science tell us about what is in the best interest of the child, and how does that connect to this debate? How does that speak to the current system and some of the proposed changes? Next time I'll get on the mic. Okay, let's go first to Martha on that.
So right now, the Children's Law Reform Act has a provision to Section 24(2) that has a list of factors that define best interests. The proposed bill proposes to add like another 6 or 8 factors to that. There's a lot of case law about how subjective best interest is, how like leading Supreme Court of Canada justices saying nobody knows actually how to define that. It's totally subjective, depends on the judge, like how do you define it? And so the idea of adding more factors is about meeting that need. But there is like a principle in family justice generally, which is individualized justice. So this child, this day, this family. So when people are talking about best interests, I always encourage them to focus on actually coming back to the individualized approach to expressing all the things about whatever they're proposing in very specific detail, how that meets the best interest of the child.
We do struggle with the fact that it's this amorphous thing, and the federal statute had only 2 factors in it, a maximum contact provision and a friendly parent provision. The provincial statutes across the country had a series of more granular factors, love, bonding and affection, stable home, etc. So we're modernizing the federal legislation, Bill C-78. It's not all bad. There's a lot of good in refreshing something that hasn't been looked at in several decades. But the question that we struggle with best interest is it's so amorphous that we're not really changing the overall experience in how we do it. There's still going to be litigation, there's still going to be waste, there's still going to be trauma to children as these cases go on for 4 years or more, and the parents are lobbying and the children are under pressure, and there's uncertainty, and there's the cost to the taxpayers and the families. This legislation, unfortunately, doesn't change that.
So I wanted to stay with the science for a moment, and we're looking at what the science, or the sociologists in particular, are learning about the best interest of the child. I'm hoping we can kind of introduce that into the discussion too, because I think the science is important. But also, in particular, what we're finding about the consequences on children of growing up with two parents that are maximally involved in that child's life versus only one parent who's maximally involved. Do we have sociological research that speaks to that question?
A well-known social scientist in Colorado, Leonard Kopetsky, in the 80s wrote a series of articles about how 2 parents in an intact family or 2 parents in separated families provide a richer environment for the children. Different perspectives, different hobbies, different values, different ways of looking at things, different strengths, different interests, and that more enriched environment leads to better development for children, whether in an intact family or a separated family. So the goal is to continue to offer the children 2 primary parent relationships to benefit from that rich environment even after separation. And the danger is when one parent gets marginalized and you have one primary parent and somebody who you go and visit from time to time, then they get only one skill set to learn from instead of two. And so our task, our job, is to figure out how to reform the system to ensure that there's two primary parents post-separation.
Did you want to?
When I was called to the bar, there were 25 plus years ago, there were actually no long-term sociological studies that haven't done yet about children survivors of their parents' divorce, and now there really is a lot of research. Some of the best studies that are long-term ones are done by an organization out of Corte Madera, California, and they don't actually talk about a presumption of equal time quite that, but they do talk about the long-term effects of children living in high conflict situations. The long-term, one of the reports that they wrote talked about how 65-year-old survivors of their parents' divorce could tell you the color of the drapes, the day of the week, what their mother was wearing on the day their parents sat them down and said that they were getting separated. And that's like a really common experience. There's another one that there's long-term resentment and long-term pain associated with court documents, and that 20 years after litigation, spouses can still recite the meanest things their former intimate partner said to them. And that's all about promoting different ways of resolving these disputes other than in written high conflict court materials. There are sociological studies out of Australia and New Zealand that are interesting too, including the work of Jennifer McIntosh. I think that Brian and I agree generally about the ideal world. Sociological studies do want to promote maximum contact with both parents as an ideal outcome, assuming a low conflict model can be figured out somehow.
You have 1 minute.
Okay, once again, conflict has nothing to do with it. If the two parents were seeing things the same way, they would quickly settle. They would never get to court. So we're talking about what happens if they don't agree. And so the job of the system is to say, you guys can't order your affairs. We're going to have to order them for you. So it presumes that there's going to be conflict. If you then say, well, conflict prevents equal parenting, then you never get there. In fact, as I've mentioned, all the crucial studies say that equal parenting reduces conflict. And with respect to the work of Jennifer McIntosh, I would refer everybody to the work of Richard Warshak and Linda Nielsen and Ann Kruk and many others who have seriously critiqued that work, that body of work by Linda McIntosh. It's not peer reviewed. Jennifer. And you have to read the literature to just see where the debate is and where the actual peer review science is. There's a lot there to explore if you're really interested in that debate.
Thank you both. Before we turn back to equal parenting, which is, of course, the focus of the debate, I think it's important to at least do one question on what is happening in family courts right now. And I think a lot of, maybe not so much people in this audience, but I think a lot of people out there just take it for granted that equal parenting probably has something to do with how decisions are made. What is sort of the reigning paradigm? What factors are going into judgments? And what is sort of, you're both family law lawyers for a number of years, what is kind of the average or typical arrangement, if you can come up with an average or typical arrangement, coming out of a family court decision? So I think it's Martha first.
I think that the average judge in Ontario does start now in a much different place than like 20 years ago, and does start with, why can't we have an equal time arrangement? In my experience, that is now the instinct of many judges. There's old school judges that don't have it. There's some people in other jurisdictions, of course, who don't, but my experience is that there's much more of an open mind towards, and more of an attitude from judges about why we can't, like from the beginning, just start with an equal arrangement.
I generally agree with that the judiciary is much more open, and there's a ton of jurisprudence where courts have awarded equal parenting, and then you look at the factors that they looked at, and you really conclude that it's really more a matter of they're much more open to it today. But part of the reason for the required legislative change is it depends sometimes on which judge you get, urban versus rural centers, which province you're in. That rich jurisprudence of equal parenting is not evenly distributed. And that's not how we should be making these crucial decisions for our children, kind of luck of the draw, what province, what center, what judge. And so you fall back on the science and the fact that the current system isn't working. And then you say you need fundamental change.
One of the other concerns, I suppose, that advocates of family law reform bring up, and I know, Brian, I've heard you bring this up, has to do with how the current system, again, in Brian's opinion, can incentivize false allegations, bringing false allegations up in order to, well, I don't want to put words in anybody's mouth, but that is one concern that advocates of family law reform do point to on occasion. And I'm wondering if either of you, both of you, want to comment on, do you feel that that is a significant factor that is undermining family law justice currently, and would a reform, equal parenting or another reform, would that make it such that that incentivization was no longer such a big factor?
We've had lots of false allegations in my case.
We'll get to your questions shortly, okay? Hang in there.
This is one of the most vexing problems in the way family law is done today.
Sir?
Raising is one of the most vexing problems in our cases today, because in an effort to convince a court that they should have the majority of the time, the only way to do that is to unfortunately make a lot of allegations against the other parent. So the typical case, when you read the competing affidavits, it's really unpleasant. And then the job of the court is somehow to sort through all of that, which is next to impossible on a paper-based motion. So we could do two things. We could, one, as Justin says, remove the incentive to do that by making it much harder for that to actually work and create an unbalanced parenting plan. Or two, we could use our existing tools, the friendly parent principle, which is being retained in Bill C-78, and actually have more jurisprudence that says if you make an allegation and you can't back it up and it's shown to be false, we're going to put a lot more weight on that in future than we are today, where there just seems to be a relief that, oh, thank God that particular allegation isn't true after a whole police and children's aid study investigation where the kids are asked some very penetrating questions. And then it's forgotten. But you shouldn't forget it. The fact that the allegation was made in the first place is relevant. So our jurisprudence could develop there and actually put some teeth behind the friendly parent provision and deal with it that way.
So the friendly parent provision, you know what he's talking about, right? That it's, okay, so there's a provision that says if you can show that the other spouse is not going to promote your relationship with the kid, maybe you should have custody because you will. And some of those cases, I think like the leading case actually comes out of not a false criminal charge, but a false sexual abuse allegation, in which the judge says, I find this allegation by the mother to have been false. I find that she is a lion. I find that maybe she believed what the child said to her, but she's like a lion protecting her cub, and she will never see enough room for the father to play a role in the child's life, and therefore I award custody to the father. That case was called Kopaniak and McClellan. It had like a terrible ending that after the father got custody, he fled in the middle of the night to Bermuda and abducted the child for almost 10 years before the mother found them. So it also demonstrates that it's sometimes hard to know who's going to actually be friendly in the end. That was actually following a long trial. The judge thought she knew everybody and had figured everything out. I think that first of all, we have to be clear that some people who call the police and the police don't lay charges, they're not making false. Like just as a general rule, not every police report in a domestic situation is a false charge. But I don't think that we take perjury seriously enough at all. And I don't think we take malicious prosecution seriously enough at all. I just finished a private arbitration in which a mother made fake documents, created a fake email account, communicated in a fake and fraudulent way with multiple parties, and that's like about 3 or 4 different criminal code offenses. She also committed live perjury at the hearing. She took the oath, she said something, and I handed her a document that showed it was a 100% guaranteed lie. So when the hearing was over, I phoned one of my friends who's a Crown attorney, and I said, like, how come I got the best friggin' perjury charge ever here, and why does nobody charge? And they said there's just they're overburdened, there's no time. I have seen some of the worst examples of lying by alienating mothers and by people with severe personality disorders. Some of the personality disorders, the definition in the book is you can't tell the truth, right? And so how do you handle this, and what are the consequences? And the consequences in our family justice system, which generally I defend much more, I think, than everybody in this room, but the consequences on the family justice system are horrendous, and nobody gets punished ever for lying, for false accusing, or for false sexual abuse allegations, or for false reports to the CAS. There are no consequences to these things except when you're at the trial and you're in front of the trial judge, and hopefully you can knit that into a narrative that makes the trial judge recognize.
Thank you. Do you want to get into
You guys are like, I'm taking no reply repeatedly. You're giving Ludmer repeated replies, and you're cutting me on a 30-second.
We're tough.
All right, that's how it works.
I've been very good about one document. I appreciate that.
I think Martha nailed it. I'm just going to say I think Martha nailed it.
But I do want to ask a question sort of on the other side, and that, sorry, I always do that. I want to ask a question on the other side of this discussion, and that is to look at one of the criticisms, I suppose, from folks who don't agree with the position of equal parenting, and that has to do with consideration of parenting time prior to separation. That the argument goes that if there was a division of sort of caregiving labor between the two parents before the separation, and it wasn't 50-50. Why should the presumption in family court become 50-50? Can I get both of you to comment on whether that's a fair criticism of equal parenting, please?
Okay, so that rule,
No, you're on. Oh, sorry.
so that rule about what did you do before and should we stick what you did before on you after, that rule is called approximation theory, like the label of it. And the approximation theory is, let's approximate the experience post-separation for a child based on what their life was like before, okay? And that's the old school. That's like 30 years ago and more, they applied, whether or not they called it that, approximation theory all the time. So the first inquiry, like maybe up to about 10 years ago, every time was, well, who did what when, who did it before? And then everybody's scrapping about who was the primary parent, because somehow that's a label that made them win something, which it really never did. So we are like miles away from approximation theory, again, in theory, like we're supposed to be, and we don't talk about it that way, mostly because judges now recognize that the deal you made in an intact marriage to have one person spend more time with the kids and one person work more, like you shouldn't be locked into that forever if your marriage ends, and you can change, one or the other can change or improve or whatever. You shouldn't be locked into, that's the flaw with approximation theory. But it's sometimes put out, and like this question kind of was, as like, is it approximation theory or should it be a presumption of equal parenting? And right now, we do have a system that is down the middle, that is the excuse or the rationale, depending on your perspective, is all based on individualized justice. We shouldn't do a presumption of anything. We shouldn't do a presumption of approximation. We shouldn't do a presumption of equality. We should look every time at the actual child, the actual parents, everybody in the room. And whether or not you think that's the right outcome, it's what you're going to get. I'm almost 100% positive when you get Bill C-78 passed. So the question is then going to be, what's the activism? What's the law reform? What are you going to do if you want to continue to have a dialogue about promoting presumption? Because you're going to have a brand new statute. They're going to say they heard all of our perspectives at those committee hearings. I think that they passed it at second reading. Brian, maybe you know this better than I do, but we kind of went there. They had hearings for 2 days of experts, and then I think the next day or the day after, they passed the bill and they like changed to, they passed it at the next reading level right after. So somebody asked earlier the question of why do our politicians treat us this way? Why are we being treated this way? Family justice is not anything that gets them votes. There is family justice reform in the province of Ontario about property division that 100 lawyers out of 100 lawyers interviewed would agree and have agreed for 20 years need to get fixed. There's no political will. There's no taking it up. And we went and talked about this bill. We have no understanding of any consultation before they wrote it. We have no sense of why they did it, and they came forward with a draft piece of family legislation that, with respect, doesn't meet any of the concerns about family justice reform that are pressing from anybody's perspectives. They come and they say, we're going to change some labels, like that's going to make a difference. We're going to change the names of things. So people won't fight anymore about custody and access if they're called like unicorns and rainbows. They will fight if you call it, you know, angels will be fighting. So I do not understand where this came from, this bill, why they did it, but and I don't want to die a cynic, I really don't, but my cynical answer to why do they treat us this way is they are not engaged legitimately in real and meaningful family justice reform, either at the provincial or at the federal level. And this is like lipstick on a pig legislation. That's what it is. That's what I told them at the committee hearings. Like I came back to my office and said, I said lipstick on a pig, just so we're clear, I said it at the hearing. So,
It's on the record.
and Brian said, you guys have to do a presumption of equal parenting about 1,000 times in his 15 minutes. So they got all perspectives and they said, yeah, thanks a lot. And can we do third reading now? Should we vote now or should we have dinner first and then vote?
I read the committee meeting minutes where they actually made some technical changes and then passed the committee revision that they went back to Parliament for third reading. The Conservative members of the Justice Committee did move for the introduction of a rebuttable presumption. Remember, we keep dropping the word rebuttable, it's important. A rebuttable presumption of equal parenting was moved. It was outvoted by the Liberal members of the committee. So if you want to know, is it possible to make people hear you? The Conservative Party heard us. So there's another opportunity in the Senate. The Senate is not yet taken up for first reading, but it's the same process, first reading, second reading, it goes to committee, there's committee meetings, etc. There's no party discipline, if you will, in the Senate. And we have a shot if we can make the point, to Martha's point, that is this, it's going to be the same ills, and if you poll the public and you poll professionals, the current system isn't working. Too long, too expensive, too stressful, too damaging to the children while it goes on. It's not working. So it is, again, to Martha's point, disappointing that the end result is a bunch of technical amendments, some well thought out. It has its root in a paper the Canadian Bar Association wrote to the Minister of Justice just over a year ago, asking for some of these technical and modernization changes. So that's what this goes back to. But is anything going to change? No. So fundamental reform requires what we're talking about here today.
Oh, did you want to go back in? I think you get the last word on this one.
So you never know what happens at the Senate, I guess, and what kind of power individual lobbying and group lobbying can have. And I already said I don't want to die a cynic, but when Ludmer was talking, I was thinking, dream on. I think that, unfortunately, and take it from me because I've spent my career doing this work, that the way to make change in family justice is to sue the province or the feds. They don't.
Put cameras in the courtroom. Exactly.
I didn't hear what that question was. Canada's.
Put cameras in the courtroom.
Oh, put cameras in the courtroom. That's interesting. Cameras in the courtroom, judges, there would be some really rude and mean judges that might be quieter if we had cameras in the courtroom. But, you know, I think we're a long way from that we're so into openness of our court system, but we're very not on board with the camera program. So I think that's a long road. A few years ago, I was involved in a a big family justice reform project on behalf of the Advocate Society, and I went to 2 or 3 meetings at these roundtables that the Attorney General for the province of Ontario was hosting. And I left the meetings and said, I really don't like going to these like collaborative meetings in which everybody talks about what they did recently and when their next meeting is. I'm really much better at suing them. But there is a thing in charter cases, like in family justice cases, like none of the LGBT equality would ever have been achieved through lobbying, through going to Senate hearings. None of it. 0 chance. And a lot of other family justice reform that's happened through court cases happens because judges have actually the courage to write judgments that go against the grain and make Parliament or the legislature react. So that's what happened with the entire LGBT movement. It's what happened with all kinds of same-sex parenting stuff. And then in individual cases, sometimes really bad principles can be changed. I'm going to sit down. Sometimes individual cases, there can be change achieved just in an individual case that manages to go up to the Court of Appeal.
Thank you. I'm going to ask maybe 1 or at most 2 more questions, and then I promise we'll get to the audience. Family violence. I think this is one motive for why Bill C-78 was introduced. That's a significant piece of the legislation. I'd like to get both panelists to comment on that aspect of Bill C-78. How much is family violence an issue in family court decision-making right now? Does Bill C-78, does it get it right in terms of fixing that piece? Does equal shared parenting do a better or worse job with respect to coming up with the right decision that protects children and partners who are experiencing family violence in the home? Lost track of Brian.
Okay.
Yeah, Brian, thank you.
First, by way of background, family violence is obviously a relevant factor today in the legislation, federally and provincially, and it lives harmoniously with our current maximum contact principle. They just operate in parallel. If there's relevant family violence that would impact on a go-forward parenting plan, you're going to see your way very quickly past the maximum contact principle. So enhancing maximum contact with a rebuttable presumption of equal parenting will live harmoniously with much more enhanced provisions now there to deal with family violence. They just operate in parallel. And if there's, again, family violence relevant to a future parenting plan, you're going to very quickly invoke the rebuttable part of the rebuttable presumption. So they're not mutually exclusive whatsoever. The one nice thing about the expanded concepts of family violence in the proposed legislation is emotional abuse, emotional harm, retaliating against the other parent through the children. And parental alienation as a manifestation of that actually fits the definition of family violence in the legislation. There'll be a new tool to deal with parental alienation.
So I agree with all that, except I would say the following. Individualized justice also, as you all know, involves individual judges bringing their own biases and views and interpretation of the competition between those two provisions. So I know what Brian wasn't trying to oversimplify, but there would be judges who would say that the family violence thing somehow does interfere with the maximum contact or vice versa. I was going to say something else. I can't remember. If I think of it, I'll
Certainly.
say it after.
Shall we move on? I have one last question. we've had a lengthy conversation, debate, whatever you want to call it, about equal parenting. We haven't actually talked very much about gender and the gender differences, the average gender differences that operate in Canadian households. So I wanted to introduce one last question, and that is that there's, I think, general consensus that we want to promote women in the workforce, and we want to promote men stepping up and being caregivers at home. So my question is, what's the best system to do that? Are there incentives or disincentives of the current system? Are there incentives and disincentives of equal shared parenting, of Bill C-78 or other reform projects that create a society where we have more equality both in the workplace and on the home front? I think to Martha.
Okay, I also thought about what I was going to say in response to the last question, which was, I think I have a case going right now in which I am, on behalf of a father, suing a mother for damages for the tort of alienation, which doesn't exist. I made it up. But that's another disincentive, and I think somebody's going to win one of those cases. Like when I say I've got this one going, you never know what happens to it. Some judge could throw mine out by summary judgment. My people could settle the case they've got going. But I think that one is ripe. And it doesn't exactly feed into the emotional violence question, but what Ludmer said there reminded me that is another sort of a potential claim that might have effect on incentives longer term. Okay, the question was about promoting fathers who will stay home. So
And mothers in the workplace.
And mothers in the workplace, okay. So I'll tell you a secret. I have an at-home husband for 25 years who just one day he was going to stay home in the first year after our first child was born, and now it's 25 years later. So I could tell you all kinds of things about what it's like to be, from his perspective, an at-home father, which is a very different world. He never heard of it. He was a bit uptight, but he never had a community of at-home mothers. He had community of at-home mothers, but he never really had a group like the at-home mothers. He didn't fit in really. And I think there are ways, it would be ideal if we could change societal expectations. One of the things lots of people don't think about is promoting paternity leave is a really important part of changing social mores, ideas about parenting. It's also something we talk about in law firms, and about keeping the women in the law firms longer also. Because if we promote the men going, we actually promote more equality of parenting during the currency of the relationship, but in a legal system, when we're trying to sell it to law firms that they should be having paternity leave with the same attitude, because in lots of them they have it, but anybody who takes it in a big firm who's a man, they keep a secret note about, and you know what they think. So I think moving towards an idea of different ideas about promoting paternity leave and everything around the early years, paternity equality in intact relationships can promote much better outcomes in the event of a separation, and less of a paradigm of somebody saying, well, I'm the primary parent.
I agree with Martha's comments. All I can say is whatever our social policies are expressed through legislation, we need to make it gender neutral. There's a lot of social studies about the benefits of father involvement. We know the outcomes for children where there isn't an active father are poor in many ways. And fatherhood is one of the most gratifying things anybody could do. So it enhances the adult's support. So that's our job. Our job is to reform the system so that fathers aren't discouraged as on family breakdown, and that we have a structure where children get to keep fathers in their lives. And it's a multifaceted social policy and legislative response, including just acceptance of that, as Martha says, because I used to work on the big downtown national law firm platforms, and that's kind of right. It wouldn't be looked at as normal, but it should be normal, because kids need both parents.
The only other law reform thing that I would add that is critically important that I think gets missed all the time, in which I said at the parliamentary committee hearings is anybody ever going to address the legal aid crisis that we have in this country? So I wonder how many people who feel disenfranchised or mistreated by a judge in this room, I'm not saying asking a show of hands, but I'm saying I wonder how many people felt that way because they couldn't afford a lawyer and they chose to be self-represented. And do you know that the legal aid, the limit for legal aid is your household income has to be less than $27,000 a year, which means we have virtually zero legal aid coverage for virtually any family litigant across the country. And what we do is talk about changing all the family law rules so individual litigants can read the forms, making online filing for simple divorces easier. These are bandages. In order to help self-reps, there's no question we should be doing that. They are bandages on the legal aid crisis. And until we have proper legal aid, we will always have a massive access to justice problem and a great unfairness, no matter how hard judges try, because they really do try in the majority of cases to be fair, maybe even sometimes too fair to the self-rep. No matter how hard they try, I just don't think you get the same shake than if you could afford to have some kind of legal aid coverage and some kind of representation.
What Martha has said is the simple truth, but it actually leads you back to divorce reform. There isn't enough money to pay for the system we have now with courts and judges and filing offices and trials that go weeks in length, and then say, not only are we going to have that cost borne by the taxpayers, we're then going to start funding so that everybody should have a lawyer and feel entitled to individualized justice over a case that spans many, many years, resulting in a trial. Because if the two parties don't agree, the way out today is with a long and expensive trial. So the lack of legal aid funding leads you back to there really is only one answer here. Other than in the extreme cases where you would meet the rebuttable part of the rebuttable presumption, we're done. We're not funding this anymore. The taxpayers are not going to fund any more damage to our children and to families that are bankrupting themselves. Individualized justice with either one self-rep against a lawyer or two self-reps is an aspirational thought. It actually doesn't happen. They can't put in a case that a judge is even going to be able to deal with. And those trials take much longer because they don't know how to organize the evidence and put it in properly. Over half the litigants in family law today are self-represented, meaning half of the cases per se are not getting to the right answer. So you just know that the system is failing everybody today. And there's only one way out. Not more litigation, not funding litigation, less litigation.
Ryan did get one extra word in there, so
Yeah,
Mark,
it's
if you
fine.
want to go, okay,
No, it's
okay, thank you. Well, that's it for my questions. A round of applause for both Mark and Ryan. What we're going to do is we're going to take maybe for about 20 minutes now questions from the audience. So I know plenty of you have lots of questions. It's too bad we can't, there's no way to get a mic to the audience, eh? If you don't have a roving mic. All right, I'll take hands and we'll start with this lady here and then we'll sort of work our way in that direction. Please, if you wouldn't mind, repeat the question. Whoever's going to answer it first, please go ahead.
I'm the grandmother that one day could see my grandchildren and the next day couldn't. And your words about the way people like totally lie in the court filings is absolutely incredible to me. And then even when you ask them at the court, why is this happening? They tell you it happens all the time. They all do it. And there is, maybe I'm totally naive, but I didn't think that that could happen to you in a place that you're going to for justice. And the bill now is about $50,000, and now we're dealing with parental alienation, and the ticker is to go back to court and deal with that. Well, again, it's hire more lawyers. I just think it's mediation, some sort of mediation or an arbitration process that would at least allow you an honest opportunity. Like, seriously, I'm a psychiatric nurse that's worked for 41 years, and I'm nothing but a drunk, and I just can't believe it can happen in Ontario, and nothing can be done about it unless you hire a lawyer or go to court again.
Ma'am, let's let the two panelists here address your reporting experiences, okay?
I know Mark and I are both touched by your comments and your experience. This is what we go through with our clients. And right now we can only deal with the situation, with the system that we have. So ultimately, the experience that you've shared with us, grandparents as well, lose touch with children and or see children a lot less than what was happening before. It's pervasive. So litigation built for commercial disputes is probably not the way to deal with helping families restructure after separation. So the real question is, if not litigation, then what? Families that can come together with some help and come to an agreement would benefit from mediation. But the types of families that are clogging our courts are never going to come to an agreement. So if we're not going to have litigation and we can't help them come to an agreement, then there is only one answer. We're going to impose a solution on the basis that it is better than the alternative, which is years of litigation. So get used to it. You're going to have equal parenting. Make it work. Can't be any worse than what we have today is really the answer.
We're going to, Robert, can you take our next question, please?
Yeah, I think people can line up here and we'll...
Okay.
Sorry,
I'm gonna
Marshall, have you answered that?
Yeah, it's okay.
Yeah.
I said it.
I am just going to ask, and I know folks have stories that they want to share, and that's understandable. But if you do that, please make it very, very brief and get quickly to your questions so that we can squeeze in as many as possible.
So what would you recommend in terms of someone that's been in a domestic abusive relationship, parental alienation on top of that, and property stolen, passport identity, do you go to the police and file as domestic abuse? What does the judge view upon that? What is it that no lawyer's gonna tell, no one's telling me to do X, Y, and Z. It's well, it's really up to you. It's is it recommended that I do go and press police charges for individuals like myself that had identity stolen, property? What is it that we should be doing?
Thank you for the question. We'd like to take that.
Okay. Just one thing we can tell everybody, we can't, we're just beating people we don't even know. We can't actually give anybody legal advice on their particular case. This is more of a policy discussion. So, we are somewhat limited in that regard, just in terms of what's fair for everybody in our own rules.
Okay, so my question is around, sorry.
No, I think that's right. If we answered the question in some hypothetical way, we could say if hypothetically there was identity theft and domestic violence in a case, what should happen? And my general advice is it's good to get advice about whether to do that. That's actually the right question. Is it a right call? I think a lot of the time in custody and access cases where their behavior does rise to a level of criminality, it's a different thing than all the other things that are abusive. But generally, in a general rule, people should go to the police about criminal activity, I think, right? And people who have custody disputes later in their lives, or 2 years later, and come and say, there was this assault and I never went to the police, they're often very sorry that they didn't do that. But again, we can't give anybody legal advice, and we have to be really clear about that. Yep.
If nothing else, you agree on that point.
My question is around back to the cameras and public perception of what's going on in the courts. Why do we not have cameras in the courts like some of the states do, as well as recordings allowed, which, from that has helped with the corruption, I would say corruption, with a quote, in the court systems within the states, and have now changed the laws where they're now assuming shared parenting as a presumption, as well as countries like Italy and so forth. That's one question. The other one I have is around, well, go ahead and answer that.
I don't think that cameras in the courtroom is ever going to make a connection to lead toward shared parenting. These are tragedies that play out every day in court. I'm really not certain that the children in particular would benefit or would appreciate everybody peering into their family at its worst moments. So I just personally think that wouldn't be a good idea. I can't see it leading to any sort of systemic reform. It's just a real-life tragedy playing out. There's enough reality TV show type things that people want to watch for pure interest, but not actual families.
There has been some reform in this area, though, which is that Now, there is a tape recorder running and transcripts in every courtroom in the province of Ontario, and there are some circumstances in which the judge has to agree to release the transcript of that, but a lot of it you can go and get. So if there's an experience that somebody has in which it goes really badly, the transcript can be ordered without the old expense, like without requiring having to pay for huge transcripts. So,
Personally, I know of instances.
Sorry, there's a whole lineup of people, and we don't have all that much time. So we'll come back to you if you want to try again at the end of the line. I'm sorry.
Next
go ahead.
question.
My friend ahead of me mentioned the word corruption, and the perceived reaction or perception of the courts is there's a lot of corruption in there, and it's a system where the winner takes all when it comes to child support. No 50-50, they want sole custody for that child support. Obviously, with the corruption, we're referring to the so-called professionals out there that are promoting the corruption. They're promoting the high conflict. Is there any way we can go after those so-called professionals by suing them? Because I believe Martha said we should start suing the province. We should start suing. Yeah. Why not sue the corrupt lawyers out there that are promoting, and the judges? Because the judges are lawyers that became. Judges are lawyers that became judges.
Yeah, fine.
So why can't we sue those corrupt people?
you can't. Yeah, you can't sue them. You can't. They're doing their job, and you can. You can report them to the Law Society. That's
By the lawyers.
That's it. Yeah. Actually, I don't share that perspective at all. I think my Law Society serves the public in a way that doesn't always take into account the interest of defending the lawyer, actually. So, what do you want to say, Brian?
The real issue in the interplay between what we're talking about here in child support is the 40% cliff that we have since 1997 when they reformed how child support was done. And it really logically can't be justified that if you have 39% of the time, your overhead in providing food, shelter, clothing, activities, etc. doesn't count. But if you have 41%, it does count. So it's ill-considered, and it's forcing a lot of litigation where somebody tries to keep the other person below 40%, so no more than 5 overnights in a 14-day cycle, and the other person is trying to get above that. So we're mixing money and kids, and it's wrong. So in an intact family, all the money's pooled and it goes to everything. Post-separation, notionally, it should all be pooled, it should all be pro-rata to income. For stay-at-home parents, it's going to wind up being the same result because you don't really have an income. So if we got rid of the 40% cliff, it would get rid of a lot of family litigation.
Thank you.
All right.
We told them that at the parliamentary, we talked about the 40% rule at the...
We told them about the 40% rule at the parliamentary hearing. I personally said it should be abolished. It's the single worst piece of law reform since I was called to the bar. The moment they put money in with custody and access incentives, they made everybody animals, actually. Both sides. It makes it disgusting. But I think it's not that realistic that they're going to abolish the 40% rule. I would love them to. Next question.
My situation is a little bit different because I don't have a lawyer right now, but I did. And basically, he admitted to being in a conflict of interest throughout my entire case, recruiting a proxy, colluding with the other attorneys. But they also threatened me. They said if I didn't settle with them, that it'd be worse for my children. And this is what the judge wants. The judge happens to know them, my wife's aunt, who works for the Children's Aid Society. I have those documents right here.
You can't do this.
Yeah,
And
so
so
you're getting into way too many details. Please go get to your question and make it about the issue that we're here to debate.
Right, and so to me, it's about removing the incentives where all of these individuals masquerade as though they're trying to resolve an issue while they're profiting from the issue, so.
Thank you for the question. Okay, next question.
Okay. About 5 or 6 years ago, an MP from Saskatchewan, Belicat, brought a private member's bill, and it had bipartisan support, great support, went through first reading really well. And I contacted my friends and family, and everybody contacted their MPs to say, hey, go and vote for this bill, it's a great bill. And what happened was some MPs said it's bad for women, some said I don't know what it's about, but Peter MacKay says it's bad, so I'm going to vote against it. And so Peter MacKay gave it a big thumbs down, who's a lawyer. And so I'm wondering what you thought about that legislation, and how much is this a battle of the legal fraternity and the legal lobby and the Law Society? Because in my mind, tens of millions of dollars in the coffers of lawyers would be lost if we had less conflict in family law. So I'm not criticizing you, so you guys are wonderful and thank you for being here, but I wanted your thoughts on that legislation and sort of battling, hey, where's the money going? And where's the law?
Thank you.
Thanks.
So a little bit biased here because I was one of the drafters of Bill C-560 and worked with Panelist Valley-Cat to try and get it through. We got about 86 votes on second reading, and the Conservative government of the time, it was a directed vote, meaning the 39 cabinet ministers were directed to vote against a bill that was being put forward by a Conservative backbencher with a lot of support. So it would have required some votes from the Liberal and NDP members to get it into committee in second reading, but we got 86, if memory serves, votes in favor. Its time hadn't come. There was strong social science research, but it hadn't worked its way in to the bureaucrats at the Department of Justice, and so everybody was kind of operating on older social science. And we did have public opinion polling. Maybe we didn't do the kind of lobbying job that we needed to do. We're doing a more sophisticated version now. But it's all part of the debate. It's all part of the process. So, you know, I think everybody's trying hard to do the right thing. These are complicated social policy issues. You're not going to get unanimity. And there's a lot of lawyers who felt that it is the right thing. So all communities are diverse, or to use Martha's phrase, not homogeneous. So that was my take on that experience.
I hate to do this, but I think what we're going to do is we're going to cap it at, I think the next 3 questions. The 3 of you at the back, you've all asked questions before? Am I wrong about that?
You're wrong. Just me.
Just you. Okay. I don't know if we have that much time. Can we do this really quickly?
That's right.
Quick questions, quick answer? Okay.
First, I'd like to thank the committee or the board, the panel, for all your insight. I came here today knowing that C-678 wasn't going to include this equal parenting provision. It's sad, you know, I was really excited about this change that possibly was coming. I can't speak for everybody, but I don't think there's a lot of happy dads here. But moving forward, I think every one of us here have a right, every parent out there has a right, grandparents have rights to know what's our next step. What do we need to do to actually make this happen? Because it's lawyers like yourselves that put the word out, and there's some lawyers that want to pocket, you know, some profit out of this, but what do we do to move forward? I think we all deserve that.
Thank you. Good question. What's the answer?
I think you have to keep, I'd be repeating myself partly with this answer, but I think you have to keep working diligently in a grassroots way to change hearts and minds. You have to keep working towards your agenda, like on all fronts. You have to pursue that in the right cases, like a test case or 2, either as a collective or individually, and you have to think big and take a long-term view.
Fundamental reform on social policy can take decades. I mean, look at the civil rights movement in the United States. It took decades. They have this phrase, eyes on the prize, which was the name of the PBS series. And they just kept at it till it happened. Look at the work Martha did on what today we just say, well, of course there should be same-sex marriage. Why not? But it took a long time. This will happen. The sad part of the equal shared parenting debate is it will be in a decade from now. We'll look back and say how many families got damaged, how many children got damaged, how much money was wasted because we didn't wake up fast enough. It is the only answer to end the family law wars.
Thanks everyone for showing up here today. It's good to see everyone. Not much is talked about unilateral actions to create tactical advantage in litigation. My experience in court, I still have a case going, and I can say on a positive note, we should all still have faith in the system. It is hard, but I will say one thing. It's a question that I'd like answered that the judge has said to me, that there should be a rule in family law that when someone creates a tactical advantage through a unilateral decision, that there should be a rule set aside that loss of time should be granted to that other parent, which I felt was kind of a big thing to hear from a judge. And he's a very old man and well respected, but a very progressive judge. And they are there, but the issue is a lot of judges, they don't read the materials.
Sorry to do this, but please get to the question.
Yeah, so what it is what do you think about a rule like that I heard the judge say he would recommend? He thinks it would be a positive thing to have a...
Thank you.
So I think it's a good idea. I think that in law it exists a bit already. So there are, the case I talked about earlier, the Kopaniak case that ended with an abduction to Bermuda. Eventually, there was a trial and a reintegration 10 years later, and there was a lot of punishment for the breach, for the lost time. That was like measured in days and everything. So like it does happen. The thing I think is dangerous that I don't think is totally your question, but counting hours and make-up timing the shit out of each other is just the road to hell.
Well, I don't agree with it personally.
Yeah.
I think there's a positive road for everybody to get through this whole system.
Yeah.
Right? I mean, it's as clear as mud. We just need to stay positive and keep pushing.
So the other thing, I really am so happy to hear something positive and not hacking on the whole justice system. That's good. I know it's just a little bit positive. But what it reminded me to say was, I still believe that the truth comes out at trials. It's just, there's a problem with the system and how long it takes to get there. There are some cases out there in which judges are being asked to find that it's a constitutional right, like it is in criminal cases, to have a speedy hearing. But actually, the justice system, like I know Ludmer said, it doesn't work to put a justice system on a family that's designed for commercial disputes on a family. I agree with that. But also a trial as an adversarial process involving evidence, cross-examination, whatever. There's a reason that thing has lasted for however long in the history of the world. There's a reason, because the truth actually comes out at trials. So my positive thing I would say to people who are in the system and are discouraged is, you gotta hang on, you gotta take the high road, and you gotta count on the truth coming out at the trial.
It's the moral high ground, right?
And if you don't have the moral high ground, if you get down in the mud wrestling with that other person, you're all buggered. You're all done.
That's what most
Thank you for your question.
That's right.
Brian? Okay, so let's go to the next question.
Hello, everyone. I have some facts to share. There was a petition to House of Commons in 2017 calling for equal parenting as default option. And in response of the government, it says there was a review that since 2015, 79% of parenting cases caught under either joint custody or shared custody. But still, yes, this is from the government, and this is the response from the government. But this fact, but the government still refuses equal parenting. This is fact one. Fact two.
Sir, instead of a list of facts, I gotta ask you, please get to the question. It's getting quite late.
Okay, fact two was there were around 23,000 family court cases in 2009 alone. And each court day means $10,000 for one party. This means 20 billion or even more business. So my question is,
go ahead, please, with the question.
Is our big government decline equal parenting to keep this huge business for related special interest groups?
Thank you. Do I hear you?
Like, no. I mean, they had the old bill that didn't succeed. They had this opportunity when Bill C-78 came out. You think they didn't know that people were ruminating about a presumption of equal parenting for years on both sides of the debate? I don't know. I don't speak for them, but no, they're not engaged on the point.
Okay, let's go to the next question, please.
My question is two-part. Number one, in the beginning of the program, we talk about the best interest of the child. So when two parents are in the court, and one parent is asking for the money part, and the other parent is asking for the excess, is it not clear that where is the best interest of the child in the judge side? Why they just wait and they say, okay, bring those documents, your pay stubs, your bank statements. They should initiate the excess right away.
And your second part?
Second part is that when there is a allegation, false allegation or whatever, until it's proven, and particularly when it's a historic charge, that something happened 2 years back and now you're complaining. So all of a sudden the one parent is separated that, oh, he's the accused or she is the accused person, so cannot see the child. Unless until it's proven, they should have equal time with the child, because the day is gone from the child life will never ever come back.
Thank you.
So first, on the second part, the family law system is inherently conservative. And so when you get some allegations, particularly the really nasty ones, that the Children's Aid Study is investigating and you don't really know, instead of a presumption of innocence,
sorry, it's 9 o'clock. We got to get through this.
They just tend to be very, very conservative. So there's a way to deal with that, but it is an experience that others have shared. The first point that you were mentioning about what happens at the start of a case till you get the first court order is yet another reason for a rebuttable presumption of equal parenting. Because when a couple separates, until you go through the whole process, documents, pleadings, first case conference, and a motion, could be 5, 6, sometimes even more months until you get your first court order, the first rules of the game. During that period from separation for 6 to 8 months, it's the Wild West. It's possession is 9/10 of the law. It's people withholding the kids and making the other parent sign a piece of paper. I'll let you see the child, but they have to bring them back that night. That's today's system where there's no rules, where it's just a blank canvas. So if we had a rebuttable presumption of equal parenting, that would be the starting point, and there'd be rules right from separation while you started to look at other factors. So the outset of a case is a huge problem today.
Yeah, totally agree with that. But I would suggest that if you're interested in this issue about how long it takes to get to hearings, about the problems at the beginning of a separation, there is a paper that's on the Advocate Society website that's called Family Justice Reform. And the concept of the paper was to, what if you took out a blank paper and rewrote family justice? Like there were no rules and you could just start over. What would you do? And one of the things in there is that we should have a triage judge within 2 weeks of commencement of every court proceeding. The family should have a meeting with a judge, and the judge should say the following: who's moving out, who's paying what support, and what the parenting arrangement. Not we have a 4-month delay until we can have our first case conference, and then after that you can all load your weapons. But actually right away a triage judge. I've been working really hard for about 5 years just to get triage judges. There's not huge uptake, but I do believe a triage judge in every courthouse in family justice, now that we're rolling out the unified family courts across the province, should be a law reform priority that this group should also consider taking up. Especially if we don't think we are getting a presumption of shared parenting without a bunch of other work. Then in the short term, a triage judge who says, well, why shouldn't you have equal time right off the bat, could be of great assistance and reduce conflict for everyone.
I know it's 9 o'clock, that's typically where we end the events. We're going to go for 10 more minutes, but we're going to try to wrap it up in 10 minutes. So very quickly, please.
I have a comment to your comment there. Artificial intelligence. I know a few lawyers that have been looking at that. I'm in that field. But tonight we've heard that over 50% of family court cases are self-litigated. What happens when that number increases due to public perception of the outcomes? I can tell you for a fact, I'm currently telling mothers and fathers to avoid court and lawyers at all costs is to start protesting.
Thank you. Any comment? No. Okay.
My question is more related to the Office of the Children's Lawyer and Minors Counsel. I haven't heard a lot of discussions about kids who are older, but the question I have specifically relates to, is there any move to change the decision-making age from 12 to an older age? Right now, we have a system where at 12, instead of getting kids counseling and therapy, we hand them a lawyer and allow them to divorce a loving parent based on alienation and every other stuff they've been exposed to, rather than actually getting them the help they need. I don't think anyone in this room would argue that a 12-year-old shouldn't be allowed to drive or drink. Why do we allow them to choose to reject a parent based on allegations from the other parent?
That's 100% correct. Today's neuroscience teaches us that the teen brain isn't fully mature till 24 and a half. And the most important piece, the one that turns them into adults, is the last piece to mature. So the family system now is operating on failed data or old data as to how much weight should be put on the views of preteens and teens who are triangulated into their family's mess. So really the answer is children should not have their own lawyers and a seat at the table in their parents' divorce. That's integrating them into it. They need to be extricated from it, and you can still solicit their needs, their interests, what makes them tick, what do they like to do, without asking them to choose between their parents. So one thing we always try and avoid in a parental alienation case is avoid children's counsel and instead get some sort of forensic review of what's going on.
Martha, would you like to?
No, sorry.
Unfortunately, that is the end of the Q&A from the live. That concludes the Q&A from the live audience, but we have had an audience online as well. I'm sorry we forgot to go to them for questions, but Mark, is there one question that's different from the ones that we've already heard that we can maybe take another 2 minutes to address?
I have a few questions here.
Give me one.
So you repeated, I don't have a microphone. Isn't it true that the majority of litigation is from one or both litigants suffering from mental illness? A question from an online viewer. Isn't it true that the majority of litigation is from one or both litigants suffering from mental illness?
So, I don't know about a majority, but I think that a lot, almost all of the cases involving what we call alienation involve somebody who is unwell in one degree or another, and somebody who typically is also committing child abuse. I used to work for a guy who was like a senior, really well-known partner, and he used to say, it was a bit of a joke, but he used to say 10% of all cases go to trial and 10% of the population has personality disorders. You do the math. So there is kind of something to the question. There is often a connection. Not always. I mean, there are people who wish to litigate until the end for vengeance, for other reasons, out of fear, because Section 9 has incentivized everybody to put money and custody and access together. Like, there's quite a few reasons, but there definitely is a comorbidity with a lot of the really serious custody and access problems and mental illness or personality disorders, no doubt about it.
I'd agree with Martha on that. The only thing I would say for litigants, you don't have to, nor should you, nor is it productive to try and prove mental illness on the part of the other litigant. It's almost better to pitch them as normal, in control of their actions and what they do and what they don't do, and that their problematic behavior is from conscious choices. Then they're fully responsible for it. So it's a bit of a sidebar to start proving that somebody is a histrionic or a narcissist. We don't take kids away from narcissists. It's a big chunk of the population. But it's judge people by their actions, what they do, but most importantly, what they don't do that would be helpful if they did it.
Can I just add
one thing to that, which I really agree with, and we're not giving legal advice, but just hypothetically, even though we're not giving legal advice, I would suggest the following, however provocative you think it is, okay? Somebody who stands up in court and says any of the following things is not doing themselves any favors and is going to distract everybody from the best interest of the child, the maximum contact principle, and everything else, okay? If you stand up and say to the judge, the system is broken, you stand up and say to the judge, men get screwed, you stand up and say they still haven't done Bill C-78 and there still isn't a presumption in favor of equal parenting, you say my wife or my partner, either, not wife, but my partner of either gender is mentally ill. You say, this is my diagnosis, as Ludmer just said. That happens quite a lot. And any of those things, my friends, any of them alienate the judge. And you do no service to yourself to come and talk about your impressions of the system, of last time. There's a case right now out there where a self-represented litigant at the end of a hearing handed the judge a little toy kangaroo. How do you think it went? You think he got everything he wanted on the day? we have to not talk about those things in the courtroom. We can talk about those things when we're working on family justice, when we're talking about a greater history. Like, we can talk about those things with our friends in these kinds of groups, but when we are in front of the court, we should focus on the best interest of the child. We should focus on ourselves and the ways that we can add value, and we should always, no matter how painful and hideous it is, take the high road and don't go down in the dirt. That's how you succeed.
That's an argument for cameras in the courtroom.
Yeah, it is, but it is an argument for cameras in the courtroom, but Brian said earlier, there are minors at issue, and I think it's a long road to get to before we're going to have cameras in the courtroom because of the issue of minors.
The states have it. The states have it, of all places.
Yeah, but the individual.
Thanks, everybody. Appreciate that round of discussion. Before we do conclude, I do want to give Mike the last word. Mike's been very patient, and I promised I'd bring him back. So you open, let's have him close, and very briefly, please, and then we'll say our thank yous and good night. Sorry, Mark, this is no time.
Like yourself, I'm a geek. I'm waiting for machine learning, artificial intelligence, and predictive analytics to put this to bed. I think it will. But with that said, I think that a lot of things that Martha said, I think are absolutely bang on. And I was a little predisposed because of what I had read. High conflict cases are the predominant issue here. If you look at that, but that's a symptom from where I sit. The issue is there's no follow-through on the courts with regards to punishment of bad behavior. Perjury is completely disregarded. Criminal issues and criminal behavior are thrown out. In fact, I've done a little bit of math. 2011, 2012, there are 312,000 family law cases in Canada. 10% of them were considered high conflicts. That puts you at a 31,000 mark. 14% of those 31,000 were identified and categorically identified as being false allegations for criminal purposes. None were charged. In fact, if you extend that across 20 years, there's only been one charge in 84,000 cases. And if you do the math, that's 1%, that's less than 1% of 1% of 1%. It doesn't count. If we are going to learn from an outside perspective, I think we've taken a lot of advice with regards to what we need to do as a group, as an organization. Certainly I've heard sue hard and sue right. Certainly one of those statements. I agree though. I think you need to take it to a higher level. I think the judges and the lawyers though have a responsibility that when there is observed and defined and proven criminal activity in order to gain a judgment, it should be charged. Criminal laws are on books for criminal reasons. For some reason, family law disregards contract law, tort law, criminal law, and that should stop. So from that perspective, that's where I sit.
One last round of applause for all three panelists. Mike, Robert, to you, the audience, for your patience, your great questions. Again, I know this is obviously a very sensitive issue, and I'm thankful that you were all respectful in your questions and in the discussion that ensued. We put on a lot of important events that are, where the public needs to be informed, and you're not going to really hear much about a lot of these issues, unfortunately, outside of our lecture series, frankly. So please sign up and make sure that you're getting notices about those events. The sign-up sheets at the front, just outside the double doors. You can also make a donation, as I said earlier. We count on charitable contributions to sustain very unique and in many cases first-of-their-kind programs and services for boys, men, fathers, and families. So thank you very much for making a generous contribution to that. Otherwise, if you have any questions, I'll be here for a little bit, and other volunteers as well. Thanks very much again for your participation tonight, and have a good evening.